Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Live Law. We bring to you the latest and in-depth legal coverage. Coming to you with a brief of what all happened in the Indian courts today. Let me begin with the news where the Supreme Court came down heavily on the National Green Tribunal. The principal bench, as you all know, of the NGT is set up for hearing environmental matters. Presently, it is headed by Justice Adarsh Goyal, former judge of the Supreme Court. Today, the Supreme Court bench of Justices Gawai and Arvind Kumar, while expressing disapproval over the principal bench of NGT allegedly continuing to hear cases from the Western Zone where they had taken suo motu cognizance in spite of top court's restriction, said, and I quote, "The principal bench of the National Green Tribunal should know its limitations." Justice Gawai emphasized the need for the principal bench of the tribunal to follow judicial discipline. The NGT requested for time to file a reply to the application and said that it would also be filing an application with respect to the Supreme Court's October 2022 order to clarify whether the matters that had already been heard extensively by the principal bench would be required to be sent to the zonal benches having the necessary jurisdiction for fresh hearings. The hearing was adjourned to later this month. In another interesting development, the Supreme Court bench comprising CJI D.Y. Chandrachud, Justice P.S. Narasimha and Justice J.B. Pardewala today refused to entertain a petition seeking to declare the Congress manifesto for 2019 Lok Sabha polls as unfair. The court said that the petition was misconceived and devoid of any merit. This petition, filed by Adarsh Kumar Agrawal and Dr. Seema Jain, had sought directions to declare the manifesto of the Congress as unfair and against the Model Code of Conduct, and take appropriate action against the party. Through the manifesto, the Congress had promised to establish a court of appeal to hear appeals related to judgments and orders of the high courts. The party also pledged to make defamation a civil offence, to omit the IPC section 124A that defines sedition, and the need to amend the Armed Forces Special Powers Act. Further, the manifesto had highlighted the need for prison reforms. The Supreme Court today dismissed the plea filed by the Tamil Nadu government in the case concerning RSS route march. In September last year, the Rashtriya Swayam Sevak Sangh (RSS) was allowed by the Madras High Court to hold processions on October 2nd. Later, RSS filed a contempt petition saying that the state disobeyed the High Court's direction. Then in November last year, the single bench of Madras High Court, while hearing this contempt petition, modified its original order. It allowed RSS to hold marches, but 11 conditions were imposed. Some of these were to hold processions in closed premises, to not carry sticks, lathis or other weapons, to not speak ill of any individuals, any caste, religion, etc. Since RSS was not happy with these conditions, they approached the division bench this year. The division bench set aside these conditions imposed by the single bench. Against this order, the state of Tamil Nadu approached the Supreme Court. Senior advocate Mr. Mukul Rohtagi, appearing on behalf of the state government, submitted that the government was not totally opposed to the route marches, but wanted it to be restricted with conditions in certain areas. Countering the arguments, senior advocate Mr. Mahesh Jethmalani, appearing on behalf of RSS, pointed out that the state had allowed protest marches by other organizations. He said that right to assemble peacefully must not be curtailed in the absence of a very strong ground. The Supreme Court dismissed the plea of Tamil Nadu government challenging the order of the division bench of the Madras High Court, which set aside conditions imposed by the single bench. You might be knowing about the litigation going on against the privacy policy of WhatsApp. The issue was before the Constitutional Bench of the Supreme Court today, and the Attorney General for India, Mr. R. Venkataramani, informed the bench that the new Data Protection Bill is ready and will be introduced in the monsoon session of the Parliament in July this year. A 5-judge bench comprising Justices K. M. Joseph, Ajay Rastogi, Aniruddh Bose, Rishikesh Roy and C.T. Ravi Kumar took note of the submission of the Attorney General that the bill will address all the concerns raised in the present petitions. Moreover, as two judges of the existing bench, Justice Joseph and Justice Rastogi, are retiring in June this year, the bench directed the registry to place the matter before the CGI so that a fresh constitution bench can be constituted, preferably in the first week of August. The petitions in the Supreme Court have been filed against the 2016 judgment of the Delhi High Court, which refused to interfere with WhatsApp's privacy policy. WhatsApp had updated its privacy policy, wanting to share data with Facebook and allow targeted ads and direct messages from businesses. This came under huge public criticism, following which WhatsApp put the policy on hold. Amid rising concerns over the safety of judges, lawyers, and litigants in courts across the country, the Supreme Court today directed all high courts to submit their responses on the progress with respect to the installation of CCTV cameras in court premises. The direction was given to senior advocate and amicus curiae Siddharth Luthra. A bench of Justices Ravindra Bhatt and Dipankar Datta was hearing a batch of petitions seeking special measures to enhance the security of court premises. Under the scanner were incidents such as that of Jharkhand's Dhanbad, where an additional district judge was mowed down by an auto rickshaw in broad daylight. Suggestions in various petitions included the installation of surveillance cameras and the creation of a dedicated security force for courts and judges. Stand-up comedian Kunal Kamra has approached the Bombay High Court challenging the new amendment to information technology rules that empower the central government to identify fake news about itself in social media. As you know, last week, the Ministry of Electronics and Information Technology notified the Information Technology Intermediary Guidelines and Digital Media Ethics Code Amendment Rules 2023, which empowers the ministry to notify a fact-check unit of the central government that will identify fake, false, or misleading online content in respect to any business of the central government. The effect of this amendment would be that social media sites and telecom service providers will have to inform the user not to host, display, upload, store, or share any information in respect of any business of the central government that is identified as fake, false, or misleading by the fact-check unit. A bench of Justice Gautam Patel and Justice Neela Gokhale today directed the central government to file its reply by April 19th, giving details of the factual background of the rules and the reasons for the amendment, and posted the matter for hearing on April 21st. The Delhi High Court bench of Justice Vibhu Bakru and Justice Amit Mahajan has ruled that the eligibility criteria of 7 years of continuous practice as an advocate to be appointed as a district judge does not require any inquiry into the actual area of practice. The bench was dealing with a writ petition challenging the selection of a candidate in the Delhi Higher Judiciary Services on the ground that the time period spent by him in pursuing a full-time master's program in law cannot be considered as a period during which he was in active practice as an advocate. The bench said that the profession of law has expanded manyfold and it is not confined to acting or pleading before a court of law. It further said that if a person is enrolled as an advocate for a period of 7 years before the date of the application, he satisfies the eligibility criteria, unless it is established that he suspended his practice or accepted an engagement which was impermissible as an advocate. The court added that there was no difference between a person who is an advocate and a person who has practiced as an advocate. In the ongoing case of Managing Committee of Delhi Waqf Board versus Union of India and others, where a petition has been filed before the Delhi High Court regarding stopping of namaz by union government officials at a mosque situated outside the Qutub Enclave, the Supreme Court had last week requested the Delhi High Court to consider the petition expeditiously. Today, the petitioners pleaded before the Delhi High Court to list their application to allow the prayers during this Ramazan period, which is going to end on April 22nd or 23rd. The bench rejected the prayer and posted the application on 27th April. Even when the petitioner submitted that after Ramazan the matter would become infructuous, the court did not change the date. You must have heard about the famous tourist place in Punjab called Sada Pind. Ankit Chawla, who runs Sada Pind restaurant, was permanently restrained today by the Delhi High Court from using the said mark, which is registered in favor of a famous tourist place in Punjab. In October last year, the court had temporarily restrained Chawla from using the mark in question. It was found that Chawla, instead of discontinuing its use, merely changed the infringing mark to another which looked deceptively similar. Passing the final order in the suit today, Justice C. Hari Shankar imposed punitive cost of Rs 2 lakh on Chawla to be deposited in favor of an NGO based in Uttar Pradesh working for underprivileged slum children. Thank you for watching. If you wish to know more details about the cases I mentioned here, please visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us.